righty. And so
Awesome.
now I'm going to go ahead, Gary, you on.
Awesome. Awesome. Great job, Steve. Can we give a hand clap to Steve? I know
Yes.
he might be on mute.
Sure.
Great job this morning. He really kicked us off. And we're just going to continue the energy. We have Olivia Stoner. Kudos to her for getting on early. She's all ready to rock and roll. I'm gonna just give you a little bit about us. Olivia, she gave me a full rundown this week about her background, and she has a PowerPoint presentation for us that is just state of the art. So kudos to you, Ms. Stoner. But just a brief background. She's a veteran attorney. She specializes in estate planning, probate, and state administration. She loves, when I say love, she loves to assist with planning needs for families by developing estate plans that take advantage of tax strategies for the transfer of wealth. And in a lot of our Black and brown communities do not transfer wealth well. And let's be real, for whatever reason, it doesn't occur. And it's people like her that we need to go to, or at least let our grandparents, our parents know that they need to get their affairs in order, because we're all going out of here at some point. So I know me personally, I'm going to take advantage of estate planning, because then I can transfer the wealth that I accumulated on this side to the proper people and not allow the state to take over and transfer the wealth that I have accumulated. Olivia, she has her law degree from the University of Pittsburgh School of Law. She has several other academia degrees. Her office is based in Philadelphia at 3213 Wallace Street. And later on, we'll have her email address up. She's welcome to take on new clients, but she likes to deal with, I believe she said, elderly folks, that are serious about planning their estate. And also we have Chris Sample, who everyone knows, but I just give a brief background about Chris, because we might have some people on here that don't know that he's the PMBR president. And PMBR stands for Philadelphia Metro Board of Realtors, which is the Philadelphia chapter for the National Association of Real Estate Brokers, NAREB. And he's licensed he's a broker in PA, Virginia, and Maryland. I don't know why he skipped over Delaware, New Jersey. Come on, Chris. At some point, jump on those states as well. He has several professional designation, and I like to give him kudos for just creating all of this platform this morning. And I also like to say hello to everyone that's out there in the audience, especially Miss Arlene, Yvette Biggs. Who else is out there? So many other folks out there. Annette Collier. Thank you, all of you guys, for checking in today. Miss Tucker, Miss Duval, Miss Davis, Arnold, Prince, thanks for checking in. Derek, thanks for checking in. Eva, thanks for checking in. Tony, Carmela, Miss Henry or Mr. Henry. Thank you, Miss Jackson. Thank you all for all checking in. Kudos for y'all taking out from y'all busy schedule on a Saturday to check in to listen to Miss Olivia Stoner. So without further ado, I'm gonna just give you a little background on myself, then I'm gonna get out the way. I'm Gary Williams, as Chris said earlier, associate broker for Berkshire Hathaway, licensed in Delaware and Pennsylvania, and I'm looking forward to opening up an office in Chester. I'm a proud member of Phi Beta Sigma Fraternity Incorporated, Delta Sigma Sigma chapter, which is based in Chester. And that's why we had open arms for NAREB, who wanted to partner up with us, because we are based in Chester and we're trying to just create a different atmosphere in Chester for businesses minority owned businesses, a real estate office, the whole 9 yards. So if anyone is interested in developing and buying properties, I believe Chester is the next big thing that's going to come to this Delaware County area. We have a lot of stuff going on in Chester. The whole uptown, or excuse me, they call it Overtown. That's the downtown district, is going to be revamped in the next 5 to 10 years. And I happen to jump on a couple commercial buildings down there, and I'm looking to buy other buildings down there. And come on, I invite everyone that's on here to want to invest in the great city of Chester, which is the only city in Delaware County. If you don't remember anything today, just remember Chester is the only city in Delaware County. And without further ado, I'd like to invite Miss Olivia Stoner to take over. Hopefully, I didn't forget anybody. I don't know if any of my fraternity brothers are on a Zoom call. I know they had a meeting, a chapter meeting, which I am missing because I'm on this Zoom call with you guys, which I'd rather be anyway. So without further ado, Miss Olivia Stoner, please take over and
Okay.
run through your PowerPoint.
Well, thank you very much. Let's see. Let me see if I can share my screen now. With this, I got to figure out. Oh, okay. Wait a minute.
Share your screen.
Here we
Yeah.
go. Here we go. All right.
Just click right on. You should be ready. Yep.
Okay.
And we're gonna one other thing, Ms. Stoner. We're gonna hold our questions till the very end, or if Ms. Stoner, if you want to take questions whenever, just let me know, and then we'll go from there. But put your questions in the chat.
All right. Well, here's what I prefer, because I'm dealing with people who are realtors, and you might have specific questions. If there's a possibility for people to raise their hand as I'm speaking, I would rather entertain that question at that section of the presentation, because I'm going to cover a lot of information. A part of it will be Tangle Title, but
Okay.
I'd really rather answer questions when I'm on that topic.
Okay, great. So why don't we do this? Why don't we have people put it in the chat room, and during those times, Gwen, myself, and Gary will take the lead and read out the question if you want, Gary, or I can do it, or Gwen can do it.
I can do it.
Okay, great. All right, Gary will run the chat box. You got it.
Great. So that works well for me. And I would just like to give you guys a foundation of how I came to specialize in this area, because right out of law school, I really did not feel that I wanted to be a lawyer. So I was fortunate enough to obtain a job in a bank trust department. And that for 23 years, I worked as a trust and estates administrator for high net worth clients. And during that time, I was able to see how our counterparts created wealth. And they created wealth and created a vehicle through which to contain that wealth for multiple generations for hundreds of years. A lot of it acquired at a time when they had free labor, when they were able to enslave our people and amass this wealth, and then create tax laws and create a system whereby that could be kept for generations, so multiple generations. So part of this, I'm going to start with estate planning, but a part of it is going to show at the end how the trusts are managed, which is why I wanted to entertain the questions first in case I run out of time. But at any rate, this presentation actually was not all of my making, but I created it. I've modified it somewhat from my membership with an academy at one point. But the area of estate planning, you should all know that it covers everything in our lives, from the health issues, legal issues, and financial issues, because it actually starts from the first time that you begin to acquire wealth through employment and your decisions with that first employer, whether or not you elect to have the maximum withheld, or to participate in a stock purchase program, or into a retirement account. And all those kinds of decisions lead up to the point where when clients come to me later in life, a lot of it has to do with the decisions that they made early in life. But your estate plan kind of controls everything, and it's important that you consider it. And as you get older, you're forced to consider it. But when you have a plan in place, you are able to control who gets what when, and just how it should be transferred, and whether or not you want to try to set your estate plan or your assets up so that it transfers to the next generation without a lot of reduction in your wealth. And I'll give you some examples of that as we go along. Right now, in our current society, we have a lot of issues where there's second families, a lot of Medicaid planning, disability issues with heirs, especially with children who may be autistic or be disabled. And then you have the issue of families where some of the children may be out of control or irresponsible, or people are not on the same page with regard to lifestyle. And so having a plan is going to be important if you want to determine who gets what when. And so when you look at your assets, you got to understand that everything that you have an ownership interest in will become a part of your probate estate. And a probate estate is going to, so just this picture is just to give you a view that everything is going to be considered as a part of your estate. And the purpose of probate is to actually change title to the assets that are in your name to a living person, and to give notice to creditors. So in the scheme of probate, there is a hierarchy of who gets paid first, and the creditors, the administrative fees, the attorney fees, and all that, those things come off the top. But the major thing you should know is that your probate asset is, if you have any creditors at all, that will be settled up before your heirs receive anything. Now, this tangled title section, I am going to spend a little bit more time on because I'm sure that many of you deal with this. And over the last several years, I've had many clients where they have only come to me after they weren't able to sell property because the underwriters picked up a break in the chain of title or other problems in transferring title to property. And how that happens is, and I can understand too, because as I started doing that, when I retired from the bank in 2003, I started doing these presentations, and a lot of people said to me, well, we're not doing nothing because we're not going to do anything because grandma's house is heir property and we don't want to risk anything happening to it. But what they didn't realize is taking that position actually will cause problems for the next generation or the next generation, which then creates this tangled title situation. Because if a person dies owning anything in their name, it's imperative that the family address the probate of that person's estate to get the title transferred out of their name to a living person. Usually, if it's only a bank account, they will rush to the Register of Wills office and probate the estate so that they can get access to the money. Once they get access, they almost feel like it's all done. I've completed probate. I got my letters. I went to the bank. I got the money. It's done. What they didn't realize was that was just the beginning of a process when you do that. But when real estate is involved, and if they have access to the money, they tend to neglect moving forward with probate because they actually have possession of the premises. At some point in the future, what they don't realize is it may not be their children, it could be their grandchildren. And I've had situations where it's the grandchildren. I have one account now where the owner of the property has been dead for 46 years. And so when you have that kind of a scenario, wow, there's multiple generations where you don't have, where the first line of intestate heirs, which would be the decedent's children and or spouse, they're deceased. So now their heirs step into their place. So I could start with a situation where we might have had 4 or 5 original intestate heirs. Now we're up to 22 to 27 sometimes. And when that class expands that huge, it's harder to get everybody on the same page. And now you're dealing with a lot of complexities and relationships, and it's hard to bring everybody together in order to probate an estate. And so in a tangle title situation, it may be more challenging to get everybody on the same page to make the decision to sell the property because you've got a buyer. And the longest one that I've been involved in, my client started in 2010. His father had been administrator of the grandfather's estate. He was contacted by a developer because this particular property, the property had been raised, so now it's a lot, and it happened to be 2 lots on which the developer wanted to build a high rise. So the developer undertook an agreement to cover the costs. After work trying to complete this situation for 5 years, they found me in 2015, and it took me up to 2018 before I could really get this house to the table for sale. And that was because we had to probate 21 estates, and it was an Italian family. One of the surviving spouses, had moved back to Italy, died in Italy. We had to open up 11 estates before we could sell the property, because and the last one where the spouse moved to Italy, and we didn't know where she had died. We actually had to hire an air search, which took them a year to locate her death certificate in Italy. It's just a shame that they don't have a central database for everybody's death certificate because you have to know where they resided, where they died, and what county. So each county is holding that information. Maybe in the future we have some sort of central way of doing it to make it more expeditious. But at any rate, we had to do all of those estates and have everyone agree to sign off on a renunciation to appoint a particular person to represent the estate. And it took that family from 2010 to 2018 to sell the property. The developer pretty much, and the way he handled it was that he entered into an agreement for a sales price, a fixed sales price with the buyer, with the original administrator of the grandfather's estate. And then all the other costs they covered it at closing. So they paid for my fee and all the other fees for all of the additional estates. So the family got a fixed amount in that sale, but I still had to file inheritance tax returns. I had to do the full probate process for each of those estates before we could get to the table in order to probate. And then it is unbelievable. And if the owner of the property has been deceased for more than 21 years, you're not able to even go to the Register of Wills to begin to open probate without filing a petition with the Orphans Court. And the reason that they have that in place is because more than likely you will have someone's death occur within that 21-year period. And the court wants to make sure that every person who had a right to inherit is represented. So you have to file a petition where each person who is an intestate heir signs off on the content of the accuracy of the facts laid out in that petition. And you actually have to show the court, state to the court why you have to open probate after this length of time. If it deals with property, they want to see a copy of the deed along with the value of the properties to document what its market value might be. And to ensure, of course, that each person is represented, you've got to report each death in the line of descendancy. And for each person that dies, their death certificate will control whether or not it says they were married, single, or divorced. If they were married and survived by a spouse, you then have to go to the spouse's side to determine whether or not they're still alive. If they're alive, they take, if they've predeceased, or I'm sorry, if they've died after the owner, then their estate comes in because that person's right to inherit vested since they survived. So it can become very complicated. And so if I could say one thing to people, to our community, is that when anyone dies owning any property in their name, you have got to address moving forward with probate in order to get clear title and to avoid the additional expense that something like this might cost. The other concern would be inheritance tax. Inheritance tax is going to be due 9 months after a person dies, no matter when you probate the estate. So if you probate 20 years later, you may have 19 years worth of inheritance tax if there is a tax due. The upside of that in Pennsylvania is that the Department of Revenue several years ago, maybe almost 10 now, decided that when you probate an estate like this, where the person's been deceased for more than 21 years, or even, it doesn't even matter, they want a date of death valuation for the property for the purpose of the inheritance tax return. So they will not accept the sales price. So you can imagine that someone that died 20 years ago, the value of their property was much less than it is today. So it's real easy for me to create a negative or insolvent inheritance tax return for the purpose of the PA inheritance tax. But the flip side of that is that the decedent's estate incurs a huge federal income tax, capital gains tax. And that is because, in spite of the, whatever value goes on the inheritance tax return, that sets the tax cost basis for the asset. So you can imagine if I have a $5,000 or $10,000 value because that was the assessed value on the year the decedent died, but now the property is worth $200,000. Now you've got a federal income tax that's not where you can't take any real deductions from that. And it's usually a flat rate of 15 to 21% on your income tax side. And so what I have to have clients do after the sale of a property like this is to make sure that they set aside at least 15 to 20% of the proceeds from the sale to cover the federal income tax that's a hit that the estate is going to occur because of that gain. Does anybody have any questions while I'm on this Tangle Title side? If not, I'll just give you one other situation where.
Ms. Stoner, it was a question
okay.
that I sent you in the chat box.
Okay, I'm not seeing the chat box. Can you just repeat it?
Yes, yeah. It says, please explain what an intestate heir is.
Oh, okay, intestacy. The law says if you do not have a will where you actually name who your heirs are going to be, then the state determines who will inherit. Your intestate heirs are heirs of the body. So for a family, we're talking about the children of the husband and wife, or sometimes we have families where the husband has children that are not by the wife, or the wife has children that are not by the husband. But in a typical husband-wife situation, the spouse is always going to inherit 50% without a will. Spouse inherits 50%. The other 50% will go to the actual children of that person. Stepchildren do not inherit. So if you have stepchildren that you want to inherit, you've got to have a will. A will trumps everything. So you could leave your estate to anybody else that's not a relative if you like. The only exception would be that a spouse would have a right to take against your will if you've disinherited your spouse. So the law, it supports the spousal relationship, but other than that, you have to actually be a blood relative. And adoptions are an exception because when a person is adopted, they lose a right to inherit from their birth parent, and now they inherit from the adopted parent.
So if someone passes away and has no immediate heirs, and say they have a bunch of nieces and nephews, it has to be how does that work? Because
Okay.
Yeah.
Okay, so if you are an only child and you've never been married and you don't have children, then you go up to your parents. And sometimes the parents were only children. You go up to the grandparents. And then the grandparents, once you start going up, now you have a maternal side and a paternal side. So you go to the grandmother's parents. How many children did the grandmother's parents have? And when we start going up that high, you know, they had 12 children, 19 children. They had, they had lots of, so now the further up we go, the more people we bring in. But you go up to the aunts and uncles or up to the grandparent and the grandparent's siblings, and then you come down. You go up to the point where you find a level of heirs. So sometimes that's at the grandparent level. And then you go over aunts and uncles, and then you come back down. So for each person who is deceased, you have in your family tree, you have to bring in each of their heirs. And if they were survived by a spouse, that spouse takes a share. So sometimes the ownership interest of the property can get outside of the family by going to an in-law. Does that help?
Yes, indeed.
Yeah, okay. Yep. Okay. All right. Now I'm just going to explain something that I just learned maybe 2 years ago. I had a client who was trying to sell property that his great-grandmother, the great-grandmother, upon her death, she had one child. The daughter then created a deed and transferred the title to the property from herself to herself. So this was back when they weren't giving the scrutiny to real estate titles like they do today. And then once she owned it, she left it to her daughter. Then her daughter created it was the daughter who transferred it to herself. She created a trust and she transferred title in trust for her daughter and son. And when the son died, she changed the deed again in trust for the daughter. And then, so now we're down to the great-grandson. He's probating his grandmother's estate, and he's trying to sell this property. We've had to probate each estate along the line. He had to probate his mother's estate, the grandmother, and assuming we didn't know about the great-grandmother's issue, but we were just dealing with his mother and his grandmother. When it got to settlement and they did a title search, they discovered an actual break in the chain of title, because the original owner had never signed the deed. After her death, her daughter just transferred a deed to herself. So that was a tangled title that I was struggling with, because we really didn't have to try to go open up an estate from someone who had died so far, you know, it was so long ago, just to create the sale, it would have been a problem. So one of the investors who was investing in this property asked me about an affidavit of heirship. And this was the first time I'd ever heard of the affidavit of heirship. And when I went online and searched it, it turned out that in a lot of jurisdictions, the affidavit of heirship is used frequently, but I hadn't heard of it here in Philadelphia. And so what we did, and he said he had a relationship with the title company that this affidavit of heirship might have been acceptable. So I prepared an affidavit of heirship, which actually was a document that started with the great-grandmother with providing birth certificates, death certificates primarily, because the death certificate of the grandmother showed her mother, her parent, who was the original owner. Then the death certificate of the next, which showed the next. So we were able to connect the dots to bring in the affidavit of heirship to prove that my client, the grandson, great-grandson, was actually an heir to the original owner. Once I was able to produce that document and give it to the title company, we were able to sell the property. Now, and I don't actually know what the underwriters or the title company did with that document, because I don't know, you know, if I had filed a petition with the Orphans Court, it would be a court record. So I'm still trying to find out what happens with that, but I've been sharing that with people who find themselves in situations where for the underwriters, all you have to do is prove the fact that you are a legitimate heir, because what they're trying to reduce the fraud that's been happening with regard to the transfer of title. Okay, so I'm moving on from that. Now I'm going into the whole estate planning area, but I will entertain questions on Tangle Title if anything comes up. But like I said before, if you have a will, you get to appoint who gets what. You appoint the executor. If you have minor children, you want to make sure you have one. Without a will, the state determines who's going to administer the estate. During the pandemic, I got lots of calls from people where I really shared with them is in Pennsylvania, you don't need a lawyer. Well, actually, this whole area of estate planning, you don't need a lawyer to prepare your estate plan, and you don't need a lawyer to probate your estate. Both of those you can do on your own. So my goal in doing these presentations is to let people know you just need to know how to do what it is that you want to do. And for the most part, people that come to me, it's so complex that they need assistance to get it done. And so I do offer my help with that. But a holographic handwritten will is acceptable for probate. And so I encourage everyone, instead of, a lot of times people are waiting to get their thing together to go to a lawyer, put something in writing now. You have to show intent that this should be considered your last will and testament. You need to name your beneficiary. You need to say if that person should predeceased you, who might take as a contingent heir. You need to name the executor, and along with that, who might be a contingent executor. If that person doesn't serve, sign it and date it. You don't need a notary, you don't need a witness. And that will be acceptable for probate. If you have a lawyer or an official will prepared where you do have a notary and you do have 2 witnesses, that's called self-proving. Without that, your handwritten document can be presented to probate, and 2 people will have to appear and attest to the fact that they are familiar with your signature and that is your signature. And one of those people can be the person who has been named as the beneficiary. So I can tell you, I have probated a postcard that
Wow.
left everything to a person who died with no heirs, and it was a handwritten document. And it was challenged by the state attorney general, because if you have a family situation where you cannot locate an heir, and you cannot, you just can't omit them. If someone cannot be located, the state represents their share, and we notify the state attorney general, and then that person's share goes to the state of Pennsylvania.
They always want their money, honey.
With unclaimed money. Yes.
Yep.
Question. Okay.
Question, Ms. Stoner.
Yes.
The question is, should your will be recorded?
Nobody's going to record your will before your death. A will is a revocable, you can revoke it at any time and make change, alter, amend. A will gets recorded after someone is deceased.
Okay, so and that's a great question. Thank y'all for the question. Say for instance, I've had it in a couple situations where they're saying, some of the heirs or potential heirs are saying, hey, grandma had a will. And the person that was living with them looked at the will probably and said, hey, I'm not in this will. Ain't nobody getting a hold of this will, and tears it up or gets rid of it. So what happens in that situation? Now we got a missing will, or the will that, grandma had XYZ on here is no longer there. So now what happens? We're in trouble.
If the will has been destroyed and there's no copy, there's nothing you can do. It's as if it didn't exist.
Because so I think that's the reason why the person was saying, should the will be recorded or, put somewhere, maybe in a bank account or a vault or something.
A lot of people, some people do put it in their safe deposit box. And after someone dies, the safe deposit box is restricted except for the will search. They will do a will search. If a will is in the box, they will only deliver it to the person who is named as executor. Here's the other thing about the other exception. If you have a copy of the will, so let's say a person does their will, but you can't find the original, but they've shared the copy with the person that they're leaving everything to, you can have a copy of a will admitted as if it were the original, but a hearing has to be held. And in the hearing, the persons named in the will have to be notified, and all of the intestate heirs have to be notified so that they have an opportunity to step up to voice their opinion with regard to the validity of this document. So after the hearing, then it's the Register of Wills city solicitor that makes a decision with regard to whether or not the copy will be admitted as if it were an original.
Okay, I have another question. It says, how long is given for the administrator to probate the estate?
Okay, you should probate as soon as you get a death certificate.
Gotcha.
I have a client now where the person's been dead for probably almost a year, but they haven't been able to get the death certificate. And so I just had a conversation with her yesterday about this situation because the decedent only owned half of a real estate with a decedent where I handled the probate of the other probate of her estate, but we weren't aware that she held this joint property, and this was joint property that was held with a man that she had a relationship with. But so it didn't, after her death, her family didn't even know she owned this thing. But anyway, once he died, his grandchildren would like to purchase the house, except that they can't get probate. And the reason they can't get probate is because the funeral bill is not paid. You have to have the funeral bill paid before you can get the death certificate. I've only had this situation occur with regard to credit unions, because we, by statute, and this is an old statute, because they understood the dilemma of when you go to the bank to try to get access to the money, they'll tell you you need a short certificate. You can't get a short certificate until you go to the bank and open probate. You can't go to the bank and open probate until you have a death certificate. You can't get the death certificate until you pay for the funeral. So if the family doesn't have the ability to pay for the funeral, there is a statute that allows you to take an unpaid funeral bill to the bank, and the bank is allowed to pay without recourse, without any liability. They're allowed to pay only to the funeral director or to the funeral home the amount that's due on the bill, or if the account holds less than that amount, they're able to close the account out and pay it toward the funeral.
Wow.
The only banks that haven't complied with that are credit unions. So I just last night sent the client a copy of the statute and I told her this bank, you've got to, and she was saying that they said there's nothing they can do and all. I told her, what you have to do is have them send it to their legal department, and you let the legal department know that that their refusal to comply with this statute now has cost the family additional money. Now that everything is delinquent with regard to this property because nothing's been paid since the decedent's death. The family couldn't even pay for the funeral, so they're not paying for anything. So as soon as, and she's saying that there's money in the bank, so I don't know whether that's, well, it should work, because the last time I had to do this, it took the credit union maybe 4 months with their legal department stalling on this thing before we were able to open the estate. The thing about, question?
No, I just said amazing. Just wow.
Oh yeah, yes. And I should just mention too, for large estates, because sometimes I'm getting a few people now who have over $1 million, which is really great. And when you have, if you know that the person's assets may be large, one thing to consider is that you want to do probate right away, because any money paid in advance toward the inheritance tax, you get a 5% discount. So you get a discount on the tax if you pay it within the first 3 months. But for most of us, you don't even go to probate within the first 3 months. So you already lose that window. But okay, so I'm going to go forward now, just with everything that's in the decedent's name has to go through probate. And that includes any kind of limited liability or interest in corporations or any kind of thing like that. If any corporate entity, and if you have an estate that you're dealing with, you're going to file a Revenue 1500 with the Pennsylvania Department of Revenue. And so taking a look at that form would be informative, because for corporations, they have several different sections that have to be filled out, so that you have to disclose a lot of information with regard to a corporate asset. And
Ms. Stoner, what was the statute? We got a question. What was the statute called again? That statute that you—
the one with the okay, so that's Title 20.
Okay.
Chapter 31, Section 3101B, references deposit accounts. And anybody,
No.
you can Google that and it'll come right up. Okay.
Give me that again. I'm gonna put it in the chat. Go ahead. Say it again.
So it's Title 20, Chapter 31, Section 3101B. The title of that is deposit accounts, I think.
Okay.
Okay. All right. All right. So now, as I talk to people, sometimes when you don't have a lot, you can structure your assets to become non-probate assets. And so for most of us, we have a bank account and we have a house. And if you title the properties in a certain way, you can avoid probate, and avoiding probate actually avoids the whole creditor piece of it, except for secured creditors. Secured creditors like a mortgage or loans or anything like that have security on it, you got to pay them. But credit card, medical bills, all those kinds of unsecured creditors will go away if you don't have the resources to pay them. And no one inherits a person's debt. All of the debt that a person has acquired should be charged only against their own assets. And this is why sometimes through the probate process, we get to the end and there's no money left. It's actually a negative. And so the heirs are last. The heirs are the ones that lose out, but the creditors get paid and all the fees on the top end. But if you were to title your accounts in joint names, so like a bank account, the death of the first person means that the survivor inherits the entire account. The fractional share of the person who died is taxable. So you're going to pay inheritance tax, but it's a non-probate asset. If you title an account in trust for, then the owner of the account whose name is in, you own 100% of that account, but upon your death, it actually transfers to the person who it was held in trust for. So 100% of that account, non-probate account, is taxable, but it will not go through probate and not be subject to creditors' claims. The pay on death is the same as in trust for. Either one of those titles is both treated the same. You'll find the in trust for title appearing more on real estate deeds, where a parent is holding it in trust for the children. And the parent has all the incidents of ownership, can always change title, sell the property, or do whatever. But upon that parent's death, title will vest in the name of the children. And so that is a non-probate asset. It does not need to go through probate. And there's really no immediate necessity for the children to create a new deed, because just by that title, and their parents' death certificate, they can already prove that title has vested in their name. So they have the right to sell the property at that point.
Ms. Stoner.
Yes.
Even if the property has a mortgage on it, you still can title it in that way, in trust for?
Well, usually when you get a mortgage, the mortgage company does that deed through the purchase. Well, and it's probably not in trust for.
Okay.
But the security, a secured creditor is always going to get paid no matter how it's titled. You follow me? Because the property is the security for the loan, and they will always get their money if it's tied to property or an automobile. They'll take the car back, or, you know, anything like that. So I have not seen any sale that went through a mortgage company that would have this in trust for title. Here's what I've done for some people who have mortgages but would like to ensure that their child gets the property is we've prepared a deed as part of the estate plan where they transfer a title to their children or to someone else, but the deed isn't recorded. The deed, there's no statute of limitations on recording a deed. So the deed could be recorded after death. But as long as you have a fully executed deed transferring title, it will be effective as of the date of the signing of that deed. And I learned this one just by accident personally, which is why I've kind of incorporated that as part of my what I do for clients. When I came out of law school and moved back to Philly in 1988, my parents, my mother, I was born and raised right where I live now, which is Mantua. And as our neighbors started to move out in the 70s, she started buying the properties next door, on the next door, the property down the street. So they had accumulated this property. And when I came back home, my father insisted that I transfer title to my sister and I. He wanted the title out of their names. And so in 1988, I transferred all these deeds into our name. And then at that point, I guess I wasn't even thinking, I don't even know if I had the money even to record them, but I just put them all in a drawer. I forgot all about them. And in 2004, my father had to go in a nursing home and we were applying for a Medicaid grant. And I started looking up the properties. They were all in my parents' names. And I was sweating bullets. I was like, oh my God, it's all my fault, right? And then I just took a chance. I went to the recorder of deeds and they all got recorded. And when you look them up, the transfer date was 1988. So the 5-year look back was taken care of, and we were taken care of. And I was like, oh my God, because I don't do real estate law. So I wasn't really sure about how that would work, but it turns out there's no statute of limitations on recording a deed. The only thing is that it has to be delivered. And so those deeds were delivered to me, myself and my sister, and they were valid, and it moved it out of the estate for inheritance tax and for Medicaid grant kind of eligibility, because the Pennsylvania Department of Revenue says that if you transfer title to any asset in contemplation of death, it is still taxable. For Pennsylvania, in contemplation of death is 1 year. For the federal government, in contemplation of death is 3 years. So if you're subject to a federal estate tax, that's only for wealthy people, then you've got 3 years to move it out. But if in Pennsylvania, if it's within 1 year, it's out of your estate, it's no longer a probate asset, but you still have to pay inheritance tax on it, on the value, excuse me, that date of death value. Okay.
So we gotta hope and pray that they hold on for another year if it's state,
yes.
and 3 years if it's federal.
Yes.
Right.
Yes. Yes. So having a plan in advance is good. And for a lot of my clients, if this is important to them because it's a family property and all, I tell them it's more important to have the deed than the will, because if you don't have a will and you only have children, the state says your children inherit anyway.
Mm-hmm.
So, and a will you can handwrite, a real estate deed you can't. So people who can't afford to do much, we sometimes just deal with the real property and have a deed in place and let them take care of everything else otherwise, which would be okay. Okay, so this goes back to the whole joint asset situation where you put someone's name on your account. A lot of times, you have to be careful, because once you do that, that person has complete access to your asset. And I've had situations where the person that was added to the account for security purposes dies first, and now you owe inheritance tax on your own money. So it could be a double-edged sword. So you never know which way to go. Not only that, once another person's name is on your account, you're subject to their creditors in divorce proceedings, whatever problems that might come up. And sometimes if people aren't ethical and you put their name on your account for convenience, and they wind up taking your money. So you got to know who you're going to be working with when you do that.
Mm-hmm.
So this whole probate process after death is, it has a lot of steps and stages to it. Generally, it will take 12 to 18 months to complete.
Yes.
Sometimes it takes longer, 5 years. I've had for the one estate, but it was a large estate and we had a lot of heirs. It was a lot of money, but it took us 5 years to get through it. So whereas most people think you go to the funeral, you get the death certificate, you go to the bank, get the money and you give it out and you're done. When you do that, the personal representative is personally liable. So I had one woman who actually didn't understand it. Her sibling died and she and the other sibling survived, and she had one more sibling that was deceased, no will. The person owned no property. All she had was money, but being that she was single with no children, she had about 300,000 in the bank. And so when she went and obtained letters, she went to the bank, she got the money out, and she gave out the money to everybody in the family. She was thinking she was doing what her sister wanted her to do. So she distributed $20,000 to every niece and nephew, to everybody. She and her brother, who were full 1/3 heirs, took 50,000 each. And the child of the deceased sibling, who should have gotten equal 1/3, he just got the 20,000. And they all went on a trip to the Bahamas or somewhere. She gave everybody money and everybody went to celebrate the life of the sister that died. So now fast forward 2 years, Department of Revenue is suing her because they get the report directly from the bank about this 300,000. And so they send her a bill for the inheritance tax and tax it at the maximum. Woo. So she doesn't know that she owes anything. She didn't know anything about this. She comes to me and I contacted the Department of Revenue and said, how do you get this 30,000 or something? They billed her for some outrageous figure. And I asked them to show me a copy of the inheritance tax return and how did they get this figure? And it turns out that if you don't file, then they file for you and they just pick a big number based on the value of the assets. So they said no return was filed, which is why they filed it. And then she becomes personally liable for it. So I prepared an inheritance tax return and I tried to use every deduction possible because her sister had no debt.
Oh God.
And she wound up still owing in the high 20s of inheritance tax. But no one had any money to give back to her.
Yeah, left the pay.
And now she has no money. And so she had to reach an agreement with the Department of Revenue to pay monthly. So from her fixed income, she had to pay, because the person in charge who becomes the administrator becomes personally liable when anything isn't done properly, which is why I started thinking it's even more important for me to let people know you've got to, when you are the administrator of an estate, you cannot give out any money to any of the heirs until you get to the very end where you have a release from the Pennsylvania Department of Revenue. So the first thing you do is you inventory the assets, appraise them. Of course, there may be some disputes with different people, but you pay the administrative fees, you pay the debts, you pay the creditors, you pay the inheritance tax. And you have to settle up the person's final federal and state income tax obligations. And after all of that, the Pennsylvania Department of Revenue, which you probably all are familiar with, will send you an inheritance tax appraisement. And that appraisement pretty much says that the inheritance tax has been paid in full and a zero balance is due. Once you have that, now you know what is left that can be distributed to the heirs, and that's what gets distributed. And I, because I've had situations where heirs received money in advance of getting to this very end, when they're asked to sign a receipt and release to release the administrator or the executor from any further liability with regard to the administration, some of them have refused to sign. And if the administrator or the personal representative doesn't get a release from anybody, they remain on the hook for everything. So my practice is nobody gets any money until everybody signs the receipt and release and has agreed that this is what they're going to accept as their inheritance in full. If that doesn't happen, a petition has to be filed with the Orphans Court for audit of the administration, and then the court will issue a decree which releases the administrator. So it's very dangerous when people just start distributing money to the heirs and without any documentation from them that they're accepting this as, because we can make advanced distributions depending on the size of the estate. So we can do advances, but that advanced distribution is signed off where they acknowledge that if it's later found out that there was an over distribution, that they would owe the money back.
Okay.
Okay. But so that's the last thing that I do for people is the receipt and release, and accountability on how we arrived at that number is what everybody is concerned about. So my practice is that when I start working with a person, because I've had other situations where the personal representative has a lawyer, and that lawyer usually is a litigator or something. He tells them not to talk to the family members. They make it so that everything goes through the lawyer, and when you don't talk to family members and everybody's not on the same page, we have a problem. And so my approach is totally different, because this is a situation where no one's interest is greater than the other.
Yeah.
The heirs, everybody, it's either determined by what the decedent put in the will, so that's fixed, or it's determined by state law. So my point to the administrator or the executor is that you have got to keep everybody in the loop. You guys have to talk to each other, and it's the burden of accountability is on the person who is the administrator to, when she gets that or he gets that bank account every month showing what's in the bank, that's the probate asset, everybody gets a copy of the bank statements. Keep everybody in the loop. So when I communicate with the person in charge, I add every person who is entitled to inherit. So everybody's on all of mine, because now since the pandemic, everything has been virtual. So everybody is included, so that people, anyone with a concern or anyone with the issue that comes up or something, we're dialoguing together. And when I get to the end, there's no problem. I send out the receipt and releases, everybody signs it, the account gets closed, we're good. And that generally happens between, like I said, the 12 to 18 month period. Okay, and so here, this is inheritance taxes due 9 months after date of death, no matter when you open the account. If there's only real estate in the estate, then that real estate has to be sold. And here's where the problem comes, because this might be the family home, and now you have either a child living in the house or a grandchild, and they don't want to probate the estate because they don't want to leave, and they have no money to give to their siblings. So the way we work this one out is when real estate is the major asset and you have more than one heir, the other heir is entitled to inherit. So we have to do something with this property, which means it has to be sold, but it can be sold to the person who wants to live there. And so we try to work with them to make that sale happen. And only in instances where the person has such bad credit that they can't even buy it, but they've been the holdout, I try to work with them to help them find a way to finance. And if they can't finance it on their own, there's no way for them to stay. They have to come to that realization on their own. But we don't just start out by assuming that the person can't, because I try to let them work through it and try to find them with a lender that may lend money to people with bad credit and stuff like that. But I've only had one where it took us months and months until she finally realized that she had to move, because she had like 5 other siblings and everybody wanted their share of their inheritance. So the property ultimately did have to be sold. In families where they're willing to work it out, sometimes other people will give up their share, or they would be willing to take a promissory note and have that person pay them every month. That doesn't always work. So that's not a solution that anybody hardly takes advantage of. Okay, so probate is, it's expensive, and if you can avoid probate, that would be the way to go. Bond, if you don't have a will, most all wills waive bonds, but a bond would be due if the person who is going to be the personal representative, the administrator, is not a Pennsylvania resident. And a lot of times the responsible one in the family does not reside in Pennsylvania, or maybe the only heir doesn't reside in Pennsylvania. So they would have to post a bond, which is an insurance payment of a single fee that you don't get back, and it's based on the value of the asset. So what I recommend for those people is that if they have a relative or anyone that they trust in Pennsylvania, that person can serve as co-administrator with them, and then no bond would be owed. In other instances, I've had many families just appoint me to be the administrator. And then I do all the work as I would as the legal counsel, but and then there's no bond. All right. And then we have, inheritance tax creditors claims and all that comes off. The rate of tax that you have to pay Pennsylvania, it is a net tax. So you start with the gross value of the assets and you deduct all of the debts and expenses. In a lot of cases, whenever the estate is insolvent on paper, the creditor has to go away, unsecured creditors, or the Medicaid grants. If a person has a Medicaid grant, they file a claim against the estate, and then when you get to the end, if there's any money left, I've had people where the Medicaid claim, a state recovery claim, was over 200 or 300,000. But if the estate only has 5, 10, or 12,000 left, that's what they will accept to write it off. In accepting that write-off, they have to have all the paperwork showing the decedent's debts and showing the amount that's left, and then they will accept it and remove their claim.
Ms. Stoner, there's a question from Iris. Is there a statute of limitation on when the state or federal government will or may come after you for taxes due that the heirs may not have previously known about?
Okay, so are we talking about inheritance tax?
Yeah, let's say that. Yeah.
Okay, so no, the inheritance tax, that tax return is due 9 months after date of death. But if you don't file it, like the client who I counseled, they will eventually, they will send you a notice that is due, and if you don't follow through, they will eventually just go ahead and file a judgment against the personal representative. And they just come up with a number. They look at they can see the value of the real estate for the assessed value. And like the client that I had, she had the 300,000 in the bank, so they automatically knew it was 300,000. And so they just take that number and they file the judgment against the person who was in charge. And then when you try to go do something, either, or after your death, it's a claim against your estate. But if you were to try to get a loan or do anything, this judgment might pop up that you didn't even know was there. And when you investigate it, if it's tied to an estate, then you just have to go back and do the work and make the filing. Because if you prepare a legitimate inheritance tax return, and it has to be a date of death return, it's a date of death balance for everything, all of the debts and the assets. So you start with the assets and then you deduct whatever that person owed during that period after death. And then you come up with a net value, and it's taxed at the rates we have here. And if you're in a situation where you can't afford to pay the entire tax, then you're going to pay it in installments. Now, federal government, I'm not sure how they would treat the capital gains tax, but usually the federal government may not catch up with you with regard to your payment of the capital gains tax for maybe a year or two as well, if you don't report it in, because the gain occurs, like if it occurs this year in 2022, you don't file the return until 2023.
Right.
And if you've neglected to inform your accountant about the sale of real estate to which this would have been, then, and you don't say anything, it might take the IRS another year or two before they catch up with it, because in all instances, the title company's underwriters report that transaction of the sale. Mm-hmm. And the basis, the tax cost basis for that property, if the owner is living, it's going to be their purchase price. But if it's an estate, it's whatever appeared on the inheritance tax return.
Yeah. Another question. Recently purchased a house that was an estate. The inheritance tax was held. For the administrators or the money that was gained from the purchase was held by the title company. That new owner goes to rehab the property and resell it. They bought it for, say, $50,000. They go to resell it for $200,000. Do they have any tax implications other than their capital gains about the inheritance tax that, or any thing that was previously from the property, the estate property that they purchased?
I don't think so. Now, the title company holds money in escrow until they get the inheritance tax appraisement, and then they're supposed to release it to the estate. And a lot of people sometimes forget that the title company is even holding that property, but that escrow is the security that's held that will go toward the prior sale where you had a decedent. Mm-hmm. So the current owner, being that if he does, when he goes to sell it, or she, I believe the title company, when they do their search, they're not going to find any break in the chain of title. And if they have that question about the inheritance tax, proof of inheritance tax, you're going to go back to the title company, which is holding money. That's why they hold the money in escrow, to pay any tax. Let's say that the person doesn't really send you the appraisement, but at some point they should have filed the inheritance tax return, and the Department of Revenue should have what they've issued on record.
Okay.
In the most recent years, we're accustomed to referring to this statement as inheritance tax appraisement. So that's what the title companies are always asking for. Recently, they kind of changed their format and they call it a statement of account. So I have sent the title companies the statement of account, which shows a zero balance. It shows the credit of the payment and a zero balance, and they keep asking for an inheritance tax appraisement. So I can't tell you the number of times I've been trying to explain to them, this is what used to be called inheritance tax appraisement, and sometimes it says appraisement. But if there are any situations where there's multiple replies from the Department of Revenue on inheritance tax, you don't just get the inheritance tax appraisement, they give you a statement of account, because after the filing you may owe money, then you pay that, then there's the communication to where finally you get to a zero balance. It's a statement of account, which is the same thing. Okay, but I don't think that it travels to the new owner, because you still have that escrow being held by the title company, and the escrow doesn't get released until they have that statement that says a zero balance on the inheritance tax. Okay. And there is a website for the Pennsylvania Department of Revenue where you can check the status of inheritance tax returns for estates, I believe. I haven't really used it, but in some instances you can check on that. And so if you're the new buyer and you need to prove that, if that question comes up, you may be able to find the answer online if you have, through the prior sale, have the file number for that decedent's account.
Okay, we have
Okay.
about 10 minutes left.
Okay, sorry about that. Okay,
Okay.
probate takes time, multiple probates. If the decedent owned property in other jurisdictions, you have to do an ancillary probate. And so their primary is where they resided, only if they had assets, and then you go to an ancillary probate for other jurisdictions. This is incapacity with guardianships. So this is just covers, this just talks about the what you need just for your basic estate planning. A power of attorney, it could be medical and financial all combined in one. The living will is an end of life document. Most people think a living will is your will. It's how you want, to what extent you want to be kept alive. So that title is kind of misleading. And then the last will and testament, again, where you decide who inherits what. And then I want everyone to know that life insurance is the only asset that transfers completely tax-free. And many of us don't take advantage of the life insurance purchase for a whole life to make sure your premium remains the same for your life when you're young, because no one really tells you the importance of it. But I can tell you in my years at the bank, working with high net worth clients who always had multiple levels of different trust accounts on every level, from their own to the grandparent to this one, all kinds of levels of insurance and of trust. There was always another component of a life insurance trust, where a trust was created and the premiums only paid for life insurance policies. And generally, this was called a wealth replacement vehicle, because probate took so long. With a life insurance trust, all you needed was a death certificate, and each one of their heirs would be like $1 million policy per heir. So they became instant millionaires with life insurance, and there's no income tax due on life insurance, and there's no inheritance tax due. And so many people, and here's how many of my clients then, once they retired, they didn't need their retirement money. So they would just put this retirement money into a trust that was not funded with anything except to purchase life insurance. And the trust just purchased life insurance, and upon death, their family members became instant millionaires. And so I started at one point doing the going to family reunions, talking about this as maybe this is something, because back then we were doing like clubs, stock purchase clubs, where we were together and buying stock. And I thought, well, maybe families could come together and pool their money just to buy life insurance. And it's something that passes a legacy, not to the generation who are doing it, but it's the next, we've got to start thinking about how we can pass a foundation to the generation that we've never met. And so this last section is just all about how people create generational legacies. And there's a whole lot of different types of trust that could be created. I just listed a few here. And of course, most people are probably familiar with the living trust. And if you have a living trust, which is revocable, and it's called a revocable trust, interviable trust, or living trust, nothing really changes. It's just where you're taking your assets and you're transferring them over into a trust, which just has a title. And so my clients, Bill and Mary, are business owners, and they have a portfolio where they've taken their discretionary income and put it in an investment account. And so I'm suggesting that they create a trust where they become the trustors, the creators, they become the trustees where they manage it, and the beneficiaries. So they do it all themselves. Nothing really changes. Nothing, it flows right through their own income tax. So there's nothing that happened at this point. Of course, after their death, it becomes irrevocable. And then you've got to do some kind of a tax ID number for your trust. But so a trust, this type of trust is really like a standby vehicle where you can incorporate into that trust instructions for disability, or upon death, it automatically transfers. So it becomes a non-probate asset. And so Bill dies, Mary becomes the surviving trustee, but then upon Mary's death, John and Susan, their children, inherit. And the reason they were looking to do something is because they were concerned about their sons not being, able to handle, be responsible. So now you have a trustee who is managing the fund for the benefit of the children. They're entitled to the income that's generated off of this fund, and the principal is invested for growth. That's the goal, so that the remainder goes to the grandchildren and then to the great-grandchildren. So you're born into it. So if John has creditor problems, it's a totally, when a trust becomes irrevocable, it's an asset protected vehicle where no one can get to it, not your creditor, not your spouse. And the incentives, when I first started in the bank in 1980, all of the old trusts were just set up so that it distributed income outright to the children. And a lot of wealthy people realized that their families not being motivated to do anything and just being able to have all this money were irresponsible. So now we find that there's more incentives built into these trusts, where if they earn income, the trust can match the income. If they get an education, the trust do it. If they're alcohol free, which was a lot harder, but I had many beneficiaries where all we ever did was to pay for them to be in some sort of resort rehab, in and out all the constantly. But the primary and important goal would be, of course, if financial assistance was needed, where if they needed money, it would be there. There's also different trusts that could be set up just for disabled children, and that's a special needs trust. And so in a living trust, you manage it while during your life, and after death, you determine how it should go. It avoids a living probate, which is like a guardianship. It avoids the death probate because it's a non-probate asset. It has the all of the elements in that trust as to what should happen upon your death. Now, another kind of trust, if you have assets that only materialize after your death, you can set up a trust that's testamentary. In other words, your will contains the terms of a trust. The only downside to this is that your will is public record at the Register of Wills. Anybody can go pull your file and see it. Whereas a personal trust that hasn't been filed anywhere other than with your, if you're going to take your portfolio and fund it into that trust, your management company is going to have a copy of your trust, but it's not public. But a testamentary trust is public. Now, the other types of trusts are just irrevocable, because usually when I get to this part of this session, people want to know, well, how can we get away with paying no tax? Because on the other one, on your living trust, you're going to pay inheritance tax. It's a non-probate asset that automatically transfers to the next, to the generation of heirs listed in there. But the value of that trust is still going to be taxable because it didn't transfer until after your death. So keeping in mind, anything that transfers after the death of one person to another is taxable. So that's going to include your IRA, your 401k, your trust that have your accounts that have any kind of titling that transfers after, even joint accounts. But and so the question always comes up, how do we pay no tax, no inheritance tax? And the only way to pay no inheritance tax is to not own it. So during life, and many wealthy people do this, they create irrevocable trusts where they actually give the money away, but they're giving it away in a vehicle that's managed by a company for the benefit of whoever they want it to be benefit. So it could be a children's trust, life insurance trust, or a charitable trust. I'll just say this real quick. I don't know how much time I have, but the federal government,
take your time, couple minutes.
Okay, so the federal government will allow you to give away $15,000 per person per year, gift tax free. When you exceed that amount, then you have to pay a gift tax to the federal government. So it's always been standard that they would shift the wealth every year out of their own taxable pockets into a vehicle. And we're just calling this the children's trust, but it could be anybody's trust. So Bill and Mary have 2 children, so they can each distribute up to $30,000 per year. That's $60,000 per year shifts over into this trust. The income tax advantage is that now the children have a trust that's just for their benefit. It could pay tuition for college. It can distribute income to them, which would be at a lower tax bracket. And it involves them in understanding investment goals, because every year at the bank, the family comes in, the investment officer goes over the portfolio. Now we're shifting, and for when I was involved in this, the light bulb that kept going on was that these families are learned from childhood that they're always going to expect an inheritance from someone, and they already have a trust in their name, and they're already sitting down with investment advisors, and they understand investing in stock where you pay $10 for the stock and now it's worth $100 and those kinds of things. So I started thinking, how do I get my community, because we were consumers. At Christmas time, it was just a bunch of gifts. At the bank,
Yes.
the Christmas gifts were stock certificates being
Yes.
transferred from one account to the other. So these kids were getting investments. And so anyway, and so at that time, my son was at Masterman, and we had to do something to Parents' Day and stuff. So I got a stock market game, and I took it to the school and had his class play stock market for the whole semester. And they got the Wall Street Journal, and they got fictitious amount of money. And from that, my son to this day, he's loves investments, and he just researched companies, and that's his passion. Both of my kids are lawyers right now, but my son is an investment person, that personally, he doesn't do it professionally. But these concepts involve your children in the financial success of the business. For my clients, Bill and Mary, they are business owners and they lease equipment. So I say to them, one of the things they could do is the money that's in their children's trust could purchase the equipment that they are leasing. So now every month when they pay a lease for that equipment, it's the money's going back into the trust. It's completely protected from lawsuits. It's out of the reach of creditors.
Wow.
And now,
amazing. Wow. Yeah. Okay.
So this is how, and then all of the tax laws are structured to support this kind of thing. And we never have the opportunity of even learning about it or even starting it, because in my mind, and so a lot of people want to create trust, but if you can't appoint a corporate trustee or a company that's going to manage it, because you want to create something that's going to last for 100+ years. And they have minimum values. So if we can get up to that minimum and keep that portfolio going, the likelihood of it being 1 million today and 2 million in the next year is great, because that's how the stock market works. It'll fluctuate, but it's always going to appreciate in some way. And so the life insurance trust that I referred to is just how instant creation, known as the wealth replacement trust. When I started and I left the bank and I started doing these presentations, I felt that it was a way for us to create wealth. But the thing that you have to have is your good health. You got to start early, where you can get so life insurance is going to be based on age and health. Yeah. And for the most part, the majority, 99% of the people I were talking to were not insurable, not able to do it, and so not able to take advantage of it. But at this point, I just want to plant the seed so that we become aware, and you can advise your children when they get their first jobs and they get the option with the insurance with the employer or whatever, to get a whole life policy for as much as they can afford, and that whole life keeps your same premium. If you have to do term life, then as you age, it's going to get so expensive that when you get to be my age, you can't hardly afford it anymore.
Yeah.
Now, and then we have so then this whole life insurance trust, it helps promote the family investment goals of protected from lawsuits, no probate, no inheritance tax, no tax at all, except for the income tax that's generated on it. Now, the other thing that I started to observe is how they create charitable trusts. And so in a charitable trust, they can donate money into this account, which is labeled the charitable trust, and then a board of trustees determines how it gets distributed. But they're able to appoint their family members to manage this. So this is another way that this goes. And so it can be in a term of years, means that the family who created it, they receive income for a term of years. The charity receives the income for a term of years, and then the remainder comes back to the family, or the family receives the income for their life. And then upon the death of the last in the family, the charity now owns the trust in whole. Now, here's how this thing works. they have highly appreciated assets. So back in the day, there was where they had paid very little for stocks, and maybe the stock might have a basis of $5 or $10, but now it's worth $200, $300. So they're able to transfer, if they were to sell that asset, and even art, where they would pay $1 million for a piece of art, now it's worth 10 million. If they were to sell it, they would incur a capital gains that they have to pay income tax on. So what do? They create a charitable trust. They donate that to the trust. The donation gets them a tax deduction. Now the trust sells the asset, and the trust, because it's a charitable trust, does not pay any income tax. So the family still gets the stream of income, and they can benefit by having their family members sit on the board. And here's what the other thing that I saw. They would take, for the board meetings for this charity, it would be of the entire family going on some vacation to the beach or somewhere, and the charity incurs the cost of all of the expenses for everybody.
To travel.
Okay. Whoops. Okay. And so I'm at the end now. So these are the factors to consider, that when you create a trust and you transfer money to it, if it's irrevocable, you don't get it back, but the terms of the trust determine how you can terminate that trust. Because usually all trusts say if the assets aren't enough that it could be terminated. But
Ms. Stoner, you
Yes.
have a couple questions. I'll be remiss if I don't get these
Okay.
questions.
All right, so this is the end. So let's take the questions.
All right, what are your thoughts on long-term care or long-term care insurance?
I don't have it myself, but my sister does, and I would support it. I've heard, if I could have afforded it earlier, I would have it, because it's a personal thing for the sake of the person. And if you are a person who doesn't have family, like no children that you can, because I know my daughter's going to sweep me up and take me with her, but but
I love it.
Yes, but I think it's a decision you have to make, and a lot of people are single with no children today, and you want to make sure that you have adequate funds to take care of you, and it makes a difference in terms of your placement after something happens, because we're all going to age out. We're all going to get to the point, if we live long enough, where we're going to need assistance and need help.
Yeah.
So I think it's a good thing as insurance for your life as opposed to after death.
Yes, Ms. Stoner, you had 3 more slides, and one
Yeah, well,
was, there you go. Go ahead and say that one. Those 2.
Okay, so this one I put in there because when I started out, I got some flack about people, waving their head and saying, last I heard, you can't take it with you. I'm not doing nothing. Just let people do whatever they want with it. I'm not planning. I don't have, not caring about a plan. And so I started thinking about how, we're not going to move forward past this unless we understand that the Bible is in the Bible, and it says that we should think about our children's children. So when I counsel people today, it's not so much on leaving assets to your children, because they've been raised and they have their lives, but it's the grandchildren that need to have you pass the baton. So it's the children's children that we should send this to. And there are numerous sections of the Bible that tell us about leaving our legacy of what you've acquired in this lifetime to the next generation. And so with that, my point to everyone is to have a plan. Hopefully it involves generational legacy and financial empowerment through educational opportunities, because our community, we're being priced out of education and housing. And that's it. So I've recently, only during the pandemic, I kept my downtown office for over 2 years. So just in February, I was able to close that office, and now I've moved to an apartment on my first floor. My building, I live on the 2nd and 3rd floor. Now my office is on the 1st floor. It's housing all of the furniture that I just moved. So I'm still just working upstairs and doing everything remotely. But what I would like everybody to know is that I am available as a resource to the community. If you have questions and you're dealing with a probate issue, now 90% of what I do is probate. because I keep telling people they can write their own will. And unless you have a complicated situation, I can do a will for you. But more importantly, more important than a will is a power of attorney, because we're more likely to become incapacitated before death. And that incapacity is where you want to name the person that's going to take care of you and avoid a court proceeding where the court will generally always appoint someone that's not a family member.
Yes.
Okay.
That's
All
so
right.
true.
I just like to give you roses before you shut off. Eva said, you are an awesome resource. Thank you. A couple other comments are you did a great job. So Ms. Stoner, we really, really, really appreciate you.
Okay.
Really. This was an awesome presentation, PowerPoint, professional, above and beyond the call of duty. So we really appreciate it. Chris, go ahead. You want to say something? I know.
Yes, indeed. I just wanted to wrap up by saying thank you so much. This was an amazing presentation. To all my Realtus members and those who are not Realtus, please join. You can go to Philly, that's PHILLYMBR.org, and join our organization. I wanted to take just a minute to say thank you to Keisha Vaughn. I think she is still on. She is the president of the RAID chapter, which is out of Delaware. Is Keisha still there?
I'm here. Thank you. Yes.
Yeah. I just wanted you to, if you wanted to just say a shout out, and then Yvette Biggs can wrap it up, our regional vice president, and then we can just move from there.
Thank you so much, Chris, for introducing me. I got on late, and let me tell you, the past 20 minutes has been phenomenal. Thank you, Ms. Stoner. I want to bring this to our chapter as well, so that we can educate people with the importance of having estate planning, and this has been absolutely phenomenal. I heard you speak before in a previous presentation. It's good to see and hear your information more than once. So thank you so much. Thank you, Chris.
All right. Yvette, you want to wrap us up, or are you still on, or you had to go?
Yep.
Okay.
No, I'm still here. I can't see anything. So I guess because we're still sharing.
So how do I close how do I close this thing?
Okay, hold on.
How do I get myself off? Yeah.
Yeah, hold on.
And before you get on, Yvette, I'd just like to thank Phi Beta Sigma Incorporated.
Here you are. Okay.
And I'd like to
can I add on to that? There was a committee of people that helped to make this possible, along with our president.
Stop share. There we go. There we go. Sorry.
Tony Johnson, who's very passionate. She's one of our board of directors at PNBR about this topic. Myself, Gwendolyn Richardson. So I want to just thank our committee for making this today. And Ms. Stoner, we have got to figure out how to make you a part of us. I know your passion, I know your belief, and these are the kind of conversations that we need to be having with our children. Get them off of the television and all this kind of stuff, because other people have conversations like this. And we need to start taking Black wealth seriously. So I just want to thank you again. I mean, you're an excellent person. I mean, may God be with you, because all of what you're saying is what can help us to remain as a community in strength. So, and President Sample, thank you so much. This week has been fantastic. And Gary, Phi Beta Sigma, and I'm going to give a shout out to my stepson, Robert Johnson. So thank you. I hope it's been valuable for you as well.
Yeah.
Thank you, Chris. Can I make one comment? I want to thank Ms. Stoner. We met a couple of years ago, I think, and she was highly, highly referred to me. And since then, I want everyone on this call to know that we've been using her services almost relentlessly. Every time we run into any issues or problems with estate or wills, she has worked it out for our office. So Reliance Realty has used her like she was part of our stuff. There you go. And so if you have an issue, you definitely need to contact her, because she has worked out very well for us. And just to know, one of my agents said her family, those here in the state and family members in Canada, they said she was very professional. She got the job done within a week. So I just want people to know how she works for her clients. So thank you again, Ms. Stoner.
Thank you. Thank you.
All right. Thank you all so much for attending today's event. Today is day 7 of Realtus Week. So we definitely appreciate everyone who has taken the time out of their schedule to participate in the different events that have been taking place between the Philadelphia chapter and also the Delaware chapter. Once again, we want to thank Ms. Stoner, Steve, Gary, and every and anyone else who have taken the time out to put together these presentations. They were definitely valuable to everyone, and we look forward to everybody coming on board and joining the chapters. Anybody that's interested in opening a chapter, you can reach out to me directly as well. Thank you so much and have a great weekend.
All right. See y'all.
See you. Bye.
Okay. Bye.
Get to stay on, and Rose, you're going to stay on too.
Okay. Hey, that.
Hey, Annette,
Sure.
don't forget to drop off. Annette, Gwen.
Hey, Chris, I'm gonna give you a call.
Okay.
Yeah, give them a few minutes though, Annette.
You say stay on or drop off?
No, drop off. We
Okay.
wait for everybody to drop off except for Rose.
Okay. Thanks.
I think Lorraine is. Can I drop her
Yeah,
myself?
you can drop. Yeah, you can drop people yourself.
How do I do that?
Um,
I go under more, remove.
there we go. All right. So, Rose, thanks for staying on the call with us. Chris, I had a short conversation with Rose about the possibility of her being your sergeant of arms for PMBR.
Okay.
Rose has extensive knowledge, and I think she's like the head honcho for Toastmasters. I think Rose runs like a couple of different chapters, and being a part of Toastmasters, with us being on Zoom so much, she's like the go-to person, or the subject matter expert rather, for Zoom. So it would be great to have Rose, I think as long as you give her enough time, give her advance notice for her to actually run the Zoom events. Because, Rose is lively, she has the music going on in the background when it's time to take a break and that type of stuff. And she's a little bit more tech savvy with things that I know I am.
Okay.
Rose,
Oh yeah, I have no problem with that.
You there, Rose?
Yes, especially when I make a point of attending all the members meeting for PMBR. So that way, if you can give me access to the PMBR's account,